We get this question constantly. My house foreclosed 10 years ago in North Carolina. Is it too late to claim surplus funds? The answer might surprise you. I'm Avery Finnerty with the Walls Law Group, and I'm gonna debunk some dangerous myths about surplus funds deadlines. Myth 1, if it's been more than a year, the money is gone. Completely false. North Carolina General Statute 45.21.31 doesn't impose a 1 or 2 year deadline. The Walls Law Group has helped clients recover surplus funds from 5, 6, even 8 years ago. Myth 2, after 10 years, you're automatically out of luck. Not true either. Here's what actually happens with old surplus funds cases. Scenario 1, your foreclosure was 8 years ago. Most likely they are now at the NC Department of State Treasurer's office as unclaimed funds. You can absolutely still file a petition under NC General Statute 45.21.32. We've seen clerks approve these claims routinely, especially when there's clear documentation. Scenario 2, your foreclosure was 12 years ago and you just found out about surplus funds. Here's where it gets interesting. If those funds were transferred to the North Carolina State Treasurer as unclaimed property, there's no time limit to claim them. North Carolina's unclaimed property laws specifically state you can claim funds indefinitely. Scenario 3, the tricky one. The original homeowner died 10 years ago and the state was never properly handled. This creates complications, but it doesn't necessarily mean the money is lost. Heirs may still have valid claims, but they'll need to establish their legal standing, which could involve probate procedures. Now let's talk about what makes old surplus funds cases more challenging. First, evidence gets stale. The older your case, the harder it becomes to locate witnesses, documentation, and clear title records. But harder doesn't mean impossible. Second, competing claimants. The longer funds sit unclaimed, the more likely other parties, legitimate or not, might surface claiming an interest. This is why scammers often target old surplus fund cases. Third, procedural changes. Court procedures and requirements may have evolved since your original foreclosure, requiring additional steps or documentation. But here's the key insight. North Carolina courts have a strong presumption that surplus funds belong to the former property owner or their lawful heirs. The law is on your side, regardless of how much time has passed. So if you're dealing with an old surplus funds situation, here's your action plan. Step 1, determine where the funds are currently held. Contact the clerk of Superior Court in the foreclosure county first. If they don't have the funds, check with the North Carolina State Treasurer's Unclaimed Property Division. Step 2, gather documentation. Even for old cases, you'll need proof of ownership and the time of foreclosure. This might include deeds, mortgage documents, or estate papers if the original owner is deceased. Step 3, understand old cases often require more legal work. You may need title searches, probate proceedings, or complex notification procedures for multiple potential claimants. The bottom line, age alone doesn't disqualify your surplus funds claim in North Carolina. We've successfully recovered funds from foreclosures over a decade old. Don't let anyone tell you it's too late without examining the specific facts of your case. Every surplus fund situation is unique, and North Carolina law provides multiple pathways for recovery, even years after its original foreclosure. So contact the Walls Law Group today at 919-647-9599 or visit wallslawnc.com